Number 77, matter of Anonymous versus Molik. Thank you. Good afternoon, Counsel.
Good afternoon, Your Honors. May it please the Court, Kathleen Treasurer for the Justice Center for the Protection of People with Special Needs. Your Honor, with the Court's permission, I'd like to reserve 2 minutes of rebuttal time.
You may.
Thank you. The third department here has misconstrued the statute in a way that creates a substantial gap in this Justice Center's authority to order remediation of conditions known to have created an incident of neglect.
Counsel, can the center bring, can the facility itself be the subject of a report?
Yes, Your Honor.
It can.
We know that in 2 ways here. We know that, first of all, in that both the third department and the petitioner have acknowledged that under 3A(i), the facility can be the subject of a report when the subject is unknown or unidentified.
No, I understand that. But just in terms of the initial investigation, can you designate the facility as a subject?
Well, in terms of, it's a little bit more nuanced than that, Your Honor, because what happens is the report comes into the hotline and it alleges an incident of neglect, and usually, I would say probably in almost all of the cases, it's identifying an employee or a staff member at the facility as the
Perhaps just a
potential
victim,
subject.
right?
Pardon?
Perhaps just a victim at the facility?
It might be, and in that case, if they identify just a victim without a subject, then and we later find in the investigation stages that the facility is responsible.
So then can the facility be, can there be a finding of neglect be substantiated against the facility?
Absolutely, Your Honor. And that follows under, if you look at 3A and 3B, reading them together.
But I guess the question is reading 3A alone. And it seems to me the only way reading 3A alone would be if you can't identify a perpetrator, right?
Or if you cannot identify a perpetrator. You read 3A and 3B together, and they cover all the possible...
No, and I understand that issue, and I'm actually
I'm sorry.
kind of agreeing with you here on one point, or it seems to me your argument has force, is under A, to me, A small I, it seems the only way you really can get a facility responsible isn't because of the facility's failings, it's because you can't identify a perpetrator. And in that case, the facility almost stands in as the responsible party for the act itself. And the other way is because of failures on the facility's part itself.
That's correct, Your Honor. That's correct. And that's where 3B comes in, and it's very plain.
But here's the problem I'm having with some of the language in the statute, and you can help me, I hope. It seems that interchangeably, the term substantiated and unsubstantiated refers to the reports of abuse as well as to the actual abuse.
Yes, I'm sorry, Your Honor.
The reports versus the finding and the abuse, these terms are used interchangeably.
They are. The statute
So
could
what
be-
is it that's being substantiated or unsubstantiated? That's what I'm having problem with.
You have an incident reported that's alleged to be abuse or neglect. If they find that that incident is substantiated, it occurred, then we have an incident of a finding that abuse and neglect has occured.
Okay.
So you have that.
And that is substantiated, or the incident of abuse is substantiated?
The incident is reported, yeah, that the abuse or the neglect that's been alleged has actually occurred. That's what's being substantiated, as well as if we have a responsible party, then that's also being substantiated. And
Let me ask you this. Under, I think it's number 1, within 60 days of the vulnerable person central register accepting a report of an allegation. Okay, so that's someone who calls the hotline?
Right. Yes,
Okay.
that's correct, Your Honor.
Okay, so the report then, your position is that this report that we're talking about under Section 493 is eventually the one that's either sealed or goes on the register is this final report after the investigation? Is that what we're talking about?
Well, there can be multiple reports following an investigation. The hotline report is what triggers the investigation.
Yes.
So then the investigation goes, and it can come out a number of ways. It can find the incident never occurred at all, in which case, then the report's unsubstantiated. It can find the incident occurred, and that the person alleged to have been responsible is responsible for it. It could be that person.
That's substantiated.
That's substantiated.
Okay.
The person could have been misidentified, and another person during the investigation identified as the responsible party. There's going to be one unsubstantiated against the person who wasn't responsible, and a substantiated report against the person who was. That's what the substantiated reports are following the investigation.
So the substantiated report against the person who's now correctly identified as having been the person who's responsible for the alleged abuse and so forth, that goes on the register.
That will go on the register.
not gonna be
Well, it doesn't
sealed,
go on
but
the
the
register.
other-
I
but
want to
the-
just say, there's a register for the category 1, and that's different than there's a database for the lesser categories. And so the substantiated report will go into the database. The unsubstantiated report will be sealed.
And that's
So
because it's
counsel-
category 4?
I'm
Is
sorry.
that because it's category 4? So because it's not category 1, the provider doesn't go on the category 1 registered list, right?
That's correct.
But they could go on, is there a list for the category 4, which we're really arguing about here, right?
There's a database.
There's a database, but there's not a registry, there's not a...
It's not a registry. The
right.
registry is only for
Is that for
category 1.
individuals?
That's
the registry?
individuals
Okay.
in order so that they're not employed by the facilities.
So under 3B, with the lead-off language in conjunction with possible findings, whether they're substantiated or unsubstantiated, does that allow you to have an unsubstantiated complaint against an individual and still have a concurrent finding of neglect against a facility?
That's correct, Your Honor. It does, because it's the only logical way really to read this section. The whole section is devoted to abuse and neglect findings, and the findings in 3A are findings of either unsubstantiated or substantiated reports of neglect and abuse. And it's logical to read that the possible findings in 3B are actually findings of abuse and neglect.
But that's not what the appellate division said, right?
That's exactly right, Your Honor.
The
But-
appellate division said that you could only find neglect against a facility where the subject cannot be identified.
That's correct.
So then is your position on section 493 that subsection 4 should read substantiated findings as opposed to substantiated reports?
No, Your Honor.
Is that the
Well,
problem?
I think what you can, if you read B as being findings of neglect or abuse, I realize neglect or abuse are not specifically put there, but it is logical to imply those there, since that's what.
Okay, but that's fine,
so
but that's not my question. My question about number 4, that says substantiated reports, are you saying that we should interpret that to mean findings?
I'm saying that once we find findings of neglect or abuse under 3B, that's a substantiated report. Under 4.
Because it's the finding in the report?
It's the finding of the report
But
at the end of the investigation.
I thought your position was a report might contain findings that substantiate and also unsubstantiate.
Yes, there can be 2 separate reports following an
But
investigation.
then, what does this mean in 4? Only the substantiated report?
Yes, will be categorized.
So it's not the report? It's not one report
It's not
with
necessarily.
findings?
It's not necessarily one report with findings. It's a report.
Where would I figure that out from this statute? How would I know that?
I think you know that because you have you have potential findings under 3. They can
Okay.
either be under 3A, the findings that they describe there, or in conjunction with the possible findings of 3A under 3B. It can be a concurrent finding that a systemic problem caused or contributed to the incident. And the incident is one of abuse or neglect, because that's what we're dealing with here. So when you have a concurrent finding that a systemic condition caused the abuse or neglect incident, you have a substantiated report of neglect.
Okay, well, I'm having a
And
lot of
then-
problems with that because 3C seems to me to be only about an individual. I don't even know how they have standing. 3C seems to me to be about individuals as the subject of the report.
That,
They're the ones who can seek to amend the report? Because it's talking about his or her rights, not its rights.
Well, the subject, I understand that my adversary's position is that the subject of a report can't be a facility. But if you look at the definition of custodian, which they point to as support for that definition, you'll see under 488, Your Honor, that's subparagraph 2.
Yes, I appreciate that argument too, but C, which is what we're dealing with now, is, I think, cannot be read to apply to anything other than an individual, because that's all the focus is of C, and it seems to make sense to me, because they're the ones who are going to want it sealed.
Well, they'll want it sealed, but again, if the report under B can substantiate that it's the systemic conditions that caused or contributed to the incident, that's the facility, and it matches up, again, Your Honor, with
But then wouldn't C, saying subject of the report, say his, her, or its?
Not necessarily, Your Honor. I think B covers the situation where the facility is ultimately responsible for the abuse or neglect that's occurred because of
Well,
the
it may
systemic
be, I think, but the
conditions.
case really turns on who's got the authority to deal with whatever this concurrent finding is, and I'm not really clear that that's the Justice Center or the Office for People with
Well,
Disabilities,
It,
developmental disabilities. Because I agree to the extent that your argument is it cannot be that the legislature would set up a mechanism whereby there would be findings that the facility has done something wrong that's contributed to this abuse, and there's no consequences, there's no way to have oversight of that, there's nothing we can do about that. I agree with you about that. For me, the question is, does this provision mean that the Justice Center deals with that, or some other entity deals with
It's
that?
the Justice Center, Your Honor, and what makes that clear is 5C of the statute as well, because what 5C says is when there's a Category 4 report that has been made, and the Category 4 deals with conditions at the facility that have caused or contributed to the incident, then the Justice Center shall require the facility to submit a plan to remediate the conditions that led to the incident.
But didn't the facility here come in and challenge the findings and actually ultimately win? But didn't they have a proceeding before an ALJ?
They did, Your Honor. They were given the opportunity to be heard, and the Justice Center found it substantiated or refused to amend the report to unfounded.
And would that be the same procedure you would follow with an individual?
That's exactly right.
So they did apply C to the facility here.
They did. They applied it, they gave them the right to be heard, and then we went to the Article 78 proceeding here, and the substantial evidence question isn't.
Well, let me ask you about that 5C. I read it as saying the Justice Center or the state oversight agency as appropriate. Doesn't that get us back to legally appropriate? And what entity is the one that 5C is referring to? Or did I misread it? Is there something I'm missing in that provision?
Well, as appropriate, I think that's for the Justice Center to determine whether or not it's
Why
going-
would that be the Justice Center? It's in the statute.
Because
Isn't-
as appropriate, the Justice Center is the single state agency charged with overseeing the investigations of abuse and neglect, and that's consistent with.
So the Office for People with Developmental Disabilities has absolutely no authority, no oversight?
No, they do have oversight authority, Your Honor. They share that with the Justice Center, and the Justice Center has the final oversight authority over this particular.
Where does it say the final oversight? Where could I find that?
Well, it doesn't say final, Your Honor, but in the Justice Center's, in the executive law governing the Justice Center under, I'm sorry, I think it's 553(7), they are given the review power over matters that come before them. They have also been granted the powers and authority that were formerly given to the Commission on Quality of Care. So they have the authority to also inspect the facilities at any time, to monitor the facilities if they find that there's safety issues involved. They have extensive oversight authority over these facilities. They also have independent oversight authority. And that means that if you read this statute the way the third department has read the statute, meaning that they don't have authorization to require remediation when it's systemic conditions, they have that independent oversight authority over OPW, OMH facilities, and OASIS-operated facilities, so that those
The JC has
facilities.
oversight authority over the Office with People with
They have
Developmental
independent
Disabilities?
oversight authority over these facilities operated by these
Oh.
these agencies.
Thank
So
you,
it's the
Coun-
purpose of the center, right?
Pardon?
Wasn't that one of the purposes of the center?
Yes, exactly. So you would be saying that those oversight agencies would be in charge of correcting their own systemic conditions without having the Justice Center oversight.
Thank you, counsel.
Thank you, Your Honor.
Counsel?
May it please the court?
Counsel, is the facility a subject under the statute?
With the facts specific to this case?
Well, in
no,
general,
but in a general sense, I would say no. as
Well,
well.
what about 48812? Subject of a report means custodian. Custodian's defined as, could be defined as an operator or provider agency.
I believe that, I'm sorry. Yes, it refers to a custodian, and then
Right,
if you
and
go
and
to the
that
term for
custodian could be a
custodian,
subject, and
it-
so the operators can be a custodian. And if they can be a custodian, then they could be a subject of a report, right?
well, it's the operator of a facility or provider agency. So it's
Right.
an individual, not the
Wow.
facility itself.
Well, we've got to say that an operator is an individual?
Yes,
We couldn't see that as a corporation?
according to the terms of what's in the definitions of 488 subsection 2, a director, operator, employee, volunteer of a facility, those are all individuals of the facility.
So who was
I
it
see.
that made the request here to amend the report?
It was the facility that made the request.
So how do
to-
they have, how does the facility have the right to make that request if it's not a subject?
Because the Justice Center had taken upon themselves to have, and goes towards what's at issue in this case. The Justice Center believes that these concurrent findings equate or allow them to make a Category 4 finding of abuse and neglect against the facility. And
Right, but under the statute, only certain people can seek to amend the report. So if there may be procedural means for you to challenge that, but it's hard for me to understand how you can say on the one hand, the facility is not a subject, but on the other hand, the facility has the right as a subject to do certain things.
Right.
That seems inconsistent to me.
And I understand your point. The facility maintained that they were not supposed to be a subject. However, the Justice Center was carrying on that they were a subject, so they requested to amend, and there was an administrative hearing, which is in the report. And there was also, and where there had to be a reconstruction hearing as well, because some of the testimony got lost.
So it was the basis for the hearing under 3C, even though that only refers to individuals? Or at least that's the way I read the provision?
Yes, and the facility did that to preserve their issue to get to this point.
So if the facility had not done this, as an entity, forget the individual for one moment, as an entity had not pursued this administrative process that seems to be laid out in 3C, you're saying it could not have gone to an Article 78? It had no other way to challenge?
Correct.
So you concede that even though 3C, as I say, I read it as referring to individuals, you concede that this does also apply to a facility, to an entity?
No, I do not.
So what were you doing in this hearing?
The facility, let me back up. This was one of the first reports that came through once the Justice Center was established. And so when this report that it was going to be substantiated, that the facility was going to be found for the Category 4 findings, what the facility did is they wanted to, either amend or repeal the findings. So, went according to the statute, didn't agree that they should be a subject to the report. However, still wanted to preserve their issue and take the opportunity, and so that's why they
So what's the remedy if you win here and this happens again? And the Justice Center can't do anything because they're not going to be able to identify a subject who's responsible because you haven't changed your policies, and nobody's forcing you to change your policies because they can't come in and say you have to make these changes. So this just keeps happening.
Well, I disagree that it would.
Well, it's happened 3 times now, right?
Sorry?
It's happened, this is the 3rd incident, right?
With this individual.
Right. So
Yes.
what's the remedy? If you win, Justice Center is powerless against the facility because every time they come in, no individual is going to be responsible, no recourse against the facility. What happens?
Well, the Justice Center isn't the end-all, be-all. As we've stated prior, there is the Office for People with Developmental Disabilities, where each year they do a yearly review. And they can also impose penalties such as fines.
So when did the first incident occur here? What year?
I believe the first incident occurred back in 2012, if I remember
And
correctly
in
from the
these
record.
yearly reviews, they obviously have no effect on changing your policies, right? Since it happened again.
From the record, they did make note of this individual having tendencies to do what he did, but they couldn't say for certain about how to handle it. And
So
that's.
that was ineffectual, those reviews.
Well, not necessarily. I mean,
Well,
the
if
resident.
you look at effectual in terms of stop to the next assault, it was ineffectual.
Well, the residents that reside at these ICFs, these intermediate care facilities, they're not, they're supposed to be allowed free will to be able to live their life, you know, in a way that society would hope that they would live. And so just an allegation or an incident of him or of an individual acting in a certain manner, take note, which is what they did, and then they assess of what to do. And they have people who work in the facility who, you know, sit and have background and education of how to deal with this sort of thing.
Doesn't the result you're advocating give an incentive to the Justice Center to find an individual responsible just so they can get to the facility?
No, I wouldn't. I wouldn't say. I would hope that the Justice Center wouldn't do that, and that's because the Justice Center should recognize that the Justice Center isn't the only one that, you know, has some sort of influence on the facilities, and keep note
But
that.
that's the purpose of the Justice Center, isn't it? To sort of coordinate all of this, to streamline it, I mean, OPWDD has a lot of responsibilities, and the Justice Center has a much narrower set of responsibilities.
Right, dealing with the adjudication side of things, and it's my position that it's OPWDD that deals with the.
You know, the problem is that that isn't really clearly sent out. It seems that we go through about 7 levels of analysis to get down to whether or not there's a custodian / operator, can be a person or can be an entity. Doesn't it force us to look at the statute as it may be ambiguous?
It does.
Wouldn't you say that this statute, that we need to, if we're in our analysis, we need to really step back behind and say, well, all right, what was the meaning? What did the legislature intend here?
Right.
And we're almost forced into that analysis. And see, I'm wondering, because if we're forced into that analysis, then when I look at the legislative history here, there's the Sundrum report, and that seems to support the Justice Center's position when I look at the underlying legislative history. So you see the problem. Once we get to ambiguity,
Right.
And
But.
if anything's ambiguous, this seems to really scream out ambiguity. And so as a result of that, when we're looking at the legislative history, then it doesn't seem to be favorable to your position that the provider could skate, so to speak, by saying that because you knew the subject, we can't be held responsible.
Well, I'm sorry, but I would disagree with the facts specific to this case. I don't think the statute is ambiguous. I think that it's clear that if there's an unsubstantiated finding, and then in conjunction, they find a concurrent finding that there were systemic problems at the facility, that doesn't get you to putting it into a category, because it has to be a substantiated finding to get you into a
Then
category.
it gets you nothing, because if you conceal it, you can't use the provision about referring it to the Medicaid inspector because it's not substantiated. You can't take any remedial measures under Section 4. So what would the purpose of the concurrent finding be?
Is to put the facility on notice of
In
the
a
issue.
sealed record that has no effect on the facility?
Well, the facility, as I stated, has OPWDD as the oversight, and OPWDD is working with the Justice Center.
So
along with-
OPWDD gets a copy of the report regardless of whether or not it's sealed?
That I am unsure of.
So then how would they be involved? How do they inject themselves into this process, according to you?
I'm purely speculating, but I would just assume that OPWDD gets a report.
Counsel, if a proceeding's brought against an individual staff member, does the facility provide counsel for that individual?
In some cases, yes.
Thank you. Thank you, counsel. Counsel?
To answer your first question, Your Honor, an operator can be a business corporation, as is the case here, where United Helpers is the, for all intents and purposes, operator and the facility. So that does seem to undermine the idea that a facility cannot be the subject of the substantiated report.
Your opponent seems to argue not to worry about the process because there are other regulatory bodies out there that will keep the facilities in check.
Well, that was the problem that led to the enactment of the statute in the first instance. There were 6 different oversight agencies that were applying different standards of abuse and neglect, conducting their own investigations or having the facilities do so, and reaching inconsistent results. As a result of that, what the Sundrum report found was there were huge gaps in the protections that were supposed to be afforded to the individuals who are residing in these facilities. And for that reason, the Sundrum report recommended the creation of the Justice Center, so that it could oversee and be the centralized authority for investigations into abuse and
Now we're
neglect.
at the place, because you're new, now we're at the place where we're trying to understand based on, let's say, not the best drafted statute, or there's some, I shouldn't be, that's not fair. There's some difficulty getting through the statute. Okay, so we're trying to figure out the authority. So again, I'm having difficulty understanding 5C's reference to the Justice Center or the State Oversight Agency as appropriate.
That's correct, Your Honor. But it's the Justice Center shall require, that's 5C. The Justice Center shall require the facility to, I'm sorry, I'm going to find the language exactly here. Shall require the facility or provider agency to develop and implement a plan of prevention and remediation.
Right, but I'm referring to the third sentence. Such plan must be approved and by its implementation monitored by. And it says the Justice Center or the State Oversight. So you may have a shall up there, but I'm unclear as to whether or not you get to approve it to begin with.
I think they can. I think they're supposed to, by the fact that it says such plan must be approved by and its implementation monitored by the Justice Center or the State Oversight Agency, and I think it's the Justice Center that decides whether or not it's appropriate.
Yes, but, so help me here. Why is it the JC and not whatever is the State Oversight Agency? How are we to know who is being referred to here?
In the as appropriate language, I think, again, I think what we're looking at here is this also in connection with the legislative history. And the legislative.
And under your reading, you would not have or the State Oversight Agency?
No, I
Because
would-
always, the JC is always the one making every determination.
No, the Justice Center, and the Justice Center can delegate to the State Oversight Agency to do that. That's what it means by as appropriate. It's the Justice Center would make that
Okay,
determination.
where do I look for the delegatory power you're referring to?
I wouldn't see it in the statute, Your Honor. I do understand that it's all part of the legislative history that
So
supports.
where in the legislative history do I see that the JC can delegate? Oh, the kind of authority you're talking about?
I think it's at least implied in the Sundrum report.
But the Sundrum report is not the statute, so we're working back from the statute.
I would.
And what other than the report? Since there were recommendations in the report that never made it to the statute.
We'll look at the sponsor's memorandum and bill jacket at L 2012, Chapter 501, at pages 14 to 15. This is the sponsor saying that the Justice Center would improve the state's response to allegations of abuse and neglect, and it gives a laundry list of authority and things that the Justice Center would do. Among that was requiring providers to implement corrective action plans to prevent future incidents of neglect. That's what the sponsor is saying is the Justice Center's authority under this statute.
To require the facilities to implement.
Providers to implement corrective action plans.
To require them to, that's the language?
Requiring, yes, I'm reading it exactly, it's a quote, requiring providers to implement corrective action plans to prevent future incidents of neglect.
And does it also say those plans are the ones that are adopted and approved by the Justice Center?
It's not as specific as that, Your Honor, but it's
implicit in the context.
in the context, it's going through all the things the Justice Center is supposed to do. It's supposed to exercise the central oversight of these investigations of abuse and neglect to implement a system that's going to further protect the people in the facilities.
Thank you, counsel.
Thank you.